Okay, next up we've got misrepresentation. You can spot this. It's usually a separate paragraph, isn't it? And you can usually spot this by someone saying something which turns out later to be false, and that's the reason they entered into the contract. So that's how you spot it. And it can be defined as an untrue statement of fact made by one party to another, which is intended to induce them, so that means bring them into the contract, and which actually does induce them and bring them into the contract to enter the contract. So what misrepresentation does is makes the contract void avoidable. That's the whole contract. So we're not looking at minutiae of terms, what terms include and so on. We're saying the whole thing is void. Now the main element is then that there's an untrue statement of fact. And of course what that means is the thing is materially false. So you just need to point out where it's false and say why. Now some notes, some statements of opinions, not only representation is misrepresentations, statements of future intention, extravagant advertisements, Red Bull gives you wings, are not misrepresentation. Nobody buys Red Bull just because it says that, do they? Non-disclosure doesn't normally amount to misrepresentation, but can if it's a duty to do so, like Spice Girls and Aprilia Motors, where one member of the band had left and they were under a duty to say this because the marketing material had all 5 of them on it, so they lost value. The second element, it must be made by one party to the other in the contract. It intends to induce them into the contract, so look for the, did they try to get them to be contract by lying? And of course it must have actually induced them to enter the contract, so you need to prove that the statement was relied upon. So it's not relied upon, for example, when they do their own checks or when they inspect the goods. Once we've established there is a misrepresentation, we need to do 2 further steps. Step 1, identify which type. So it could be fraudulent, in which the statement is made knowingly or recklessly. It could be negligent, which there's a special relationship and they've just not kind of took care. Or it can be innocent, in which they may have checked it, for example, but it's still false. They might have checked it. It might be, for example, an error on the registration of a vehicle. They checked it, did all they could, but it's innocent. But there still needs to be some remedies, don't there? And that's step 3. What is the remedy now there is misrepresentation and we've established the type? Well, it depends then on what type. Because if it's fraudulent, it's rescission, so you can cancel the contract, or you can sue for damages. And of course, it'd be up to you to decide which would be best. Do we want to go back to the beginning and rescind it entirely, no obligations anymore? Or would damages be better because they've suffered a loss? The contract can be affirmed as well, so if they know it's misrepresentation and they keep on going with the contract, then they can no longer use this misrepresentation, and so instead they may just get damages. For negligent misrepresentation, it can't be action for financial loss, but again it's rescission or damages and you need to pick out which the best one. The difference here is section 2(1) of the Misrepresentation Act, so it's a statutory remedies in addition to common law remedies as it is for fraudulent. For innocent then, the contract must not have been affirmed. It must be timely. You've got to make sure that you check that you action as soon as you know there's a misrepresentation, you take some action. But ultimately the remedies are rescission or damages. So usually just be rescission. But if restitution is impossible, for example, you can't restore the diamonds to the mine, then you can get damages instead.